в микрофон. Наш keynote speaker сегодня – член комиссии международного права, доктор Rajput. Aniruddha, вам слово.
Thank you, Roman. Excellencies, honorable judges, ladies and gentlemen. I feel honored to deliver this keynote address on a topic of practical importance and daily utility for the users of international law, by which I mean states, individuals, as parties to disputes, and courts and tribunals which have to apply them. I begin by thanking the International and Comparative Law Research Center for this very kind invitation, and in particular Judge Kolodkin for this invitation, who's a very dear friend and a former colleague from the International Law Commission. I can't resist but saying on his last day in the Commission, I said, Commission's loss is it losses gain. The experience of mature legal systems at the national level shows that they have advanced substantive as well as procedural rules. The substantive norms regulate the rights and obligations of parties to a dispute, whereas the procedural norms govern the process of adjudication. A clear set of procedural norms ensures clarity and consistency in the adjudicative process, aptly encapsulated in the phrase due process. The judicial organs at the national level have existed for a relatively long period and conduct that exercise on a daily basis, which in turn has resulted into a developed norms of procedure and in particular developed norms on evidence. International law, only in recent decades, has seen a sudden rise in the number of international courts and tribunals and greater willingness of states, the principal participants in the international legal process, who are coming forth and participate in the process. One can also not ignore the effect and the increasing presence of individuals, either as private persons or corporate personalities, in involvement in these international adjudicative processes. On the one hand, the proliferation of courts and international tribunals has contributed to the growth of procedural law within international law, while, on the other hand, international adjudication demands greater attention towards procedural law. An important component of procedural law is, of course, the law of evidence. Evidence in international adjudication could be seen in two ways. First is evidence to establish a rule of law, which may be a rule of customary law or conventional law or even general principle of law. But that is not what we would be dealing with today. What we would be dealing with is evidence as a process of establishing a fact. Because evidence, while establishing a fact, often plays as a decisive role, as encapsulated in a Latin phrase, idem est non probari non est. Something which is not proved does not exist or is simply not true. In past, if not absent, but it was not often that international courts and tribunals would have to deal with complex factual scenarios. The proliferation of courts and tribunals and specialized subject matters of some of them has brought to the fore for greater attention towards issues of evidence. In the backdrop of the consensual nature of international adjudication or international dispute resolution, clarity of the process of proving the facts is crucial for the credibility of the adjudicative process. It is thus timely to ask the question, evidence before international courts or tribunals, distinct fora, similar approaches, and a question mark. From the title of today's topic, distinct fora and similar approaches, there are two principal and interconnected themes which come to my mind. Distinct fora, in my view, is not just representative of numerical plurality of courts and tribunals in today's world, but it is more than that. It represents the diversity of the subject matter. The International Court of Justice has been and continues to be a generalist institution that can comfortably adjudicate on a wide array of subject matters. It has done so in the past and would continue to do so in the future. In the present-day dispute resolution scenario globally, we see many specialized courts and tribunals. The panels and appellate body of the World Trade Organization deal with matters relating to international trade. The Tribunal on the Law of the Sea, comprising of law of the sea experts, deals with different issues relating to law of the sea. Investment tribunals involve challenges to governmental action, often involving commercial and financial component. The ICC deals with a distinct branch in itself, international criminal law, which has in a sense resuscitated over the last couple of decades. Except for the ICJ, the caseload of specialized courts and tribunals is distinct from one another. The priorities of substantive law, in a sense, the structural necessities of an institution require that institution within a precise subject matter to apply a specific law. So the panels and appellate body of the WTO would look at issues of human rights from a trade perspective, whereas European Court of Human Rights might want to look at cases from a human rights perspective, even if there might be an underlying trade component to it. The question really is whether differences in subject matter, distinction in fora, affects the principles of evidence. Another aspect of the distinctive nature of courts and tribunals is the level at which they function. Some are regional, whereas others are global. At the regional level, we have the European Court of Human Rights and the Court of Justice of the European Union in Europe, Inter-American Court of Human Rights in the Americas, and the African Court on Human Rights and People Rights in Africa. These judicial institutions have a jurisdiction limited to the region and based upon regional treaties with regional priorities. Nevertheless, they are looked upon with respect and applied by other courts and tribunals. Needless to add, even at the regional level, we have differences in subject matter. Thus, the European Court of Justice, which would be a generalist institution of the EU legal system, whereas the European Court of Human Rights would be a specialist institution within the regional architecture. Despite the differences in the subject matter and level of functioning, can thereby similar approaches to evidence be found? If yes, then what could those be? In my view, there should be similar approaches, and such common ground can be found across these diversities. And I'll try to address some of these similarities, which is the second part of this title. But before I get there, I need to touch one important aspect of the distinctions in fora, which is about presence of individuals. The role and extent of involvement of individuals in distinct fora also brings in a different angle altogether. In most of the dispute resolution systems that we would discuss today, there is a sovereign element, but there would be some without or with a limited sovereign element. One of them is sports law. It would be interesting to see how do practices from sports law have a role to play in the overall international adjudicative process, and to look at what are those similar approaches. I must say I prefer the choice of the word similar approaches. I'm aware of the book written by Chester Brown called A Common Law of International Adjudication. I'm hoping not to step on the controversy between civil and common lawyers. I would leave it best for them, because I come from one of those systems. But I do prefer similar because it has a sense of flexibility in the process. So common, even if not understood in the common law sense, might give the impression of standardization. What we are looking at is not standardization of processes of evidence. What we are looking at is similar principles, similarities of approaches from different courts and tribunals, which could be drawn upon and developed and used by different courts and tribunals. Now, what are the reasons why we should have these similar approaches, and how could these similar approaches function? If not all, and I emphasize on that, definitely not all, But there are certain aspects of evidence which are bound to remain common across the fields. At least in the literature, there is consensus on this. And this point can be well explained with some illustrations. Let us take the example of expert evidence. The substantive contents of an expert evidence are going to change not only on a case-by-case basis, but obviously on the basis of one fora than another. Despite these differences, the manner in which the expert evidence is received, analyzed, and the probative value granted to an expert evidence is not going to change. Because to that extent, expert evidence, the process of appreciating and analyzing expert evidence is bound to remain neutral or, in a sense, insulated from the substantive evidentiary issues which might arise in such processes. Let me give a slightly less controversial example. And there are many of those. One of the settled principles of evidence, which could even be treated as customary international law, or even a general principle of international law, is the rule of onus probandi incumbit actoria. That is, the claimant has the burden of proof. The claimant need not be the claimant in the case, but a claimant as a party that is asserting a certain fact. A party that is asserting a certain fact has to establish that fact. This fundamental rule of evidence, or a principle of evidence, is bound to remain similar across distinct fora, unless there is a specific rule which makes an exception in a certain situation. So it doesn't matter whether a dispute is brought before the WTO, or the appellate body or the panel, or the International Court of Justice, or before any arbitral tribunal. It remains the same across regimes. Therefore, there are aspects of evidence, if not for all, but for many of them, which remain common, which in a sense are neutral from the subject matter of the specialized regimes. There are several other areas of evidence which would relate to production of evidence, to reception of evidence, cross-examination, site visits. These principles bound to remain similar across regimes. There would be some principles of evidence where due care is required because they would be influenced by the subject matter of the dispute. Burden of proof is one of them. The case before the International Court of Justice often shows this. In the military and paramilitary activities case, the ICJ applied the standard of convincing evidence. In Bosnia genocide cases, it used the standard of fully conclusive evidence. Judge Greenwood, in his separate opinion in the pulp mills case, used balance of probabilities, a standard which is used by common lawyers to decide what are called civil cases. The divergence may appear merely of nomenclature in some situations, but it is substantive in many others. This divergence is understandable and necessary considering the nature of the subject matter of dispute, because this is a situation where the nature of the subject matter of dispute is going to influence the principle of evidence, and burden of proof is one of them. In environmental law, it may be enough to have standard of preponderance of probabilities. But in the case involving international criminal law, a higher standard of convincing proof would be required. Likewise, in land boundary delimitation, in situations of acquiescence, a higher standard of proof may be desired. There would be some areas of evidence that would be purely dependent on the peculiarities of the regime. It may not be possible to extrapolate those, but the rest can certainly be. In international criminal adjudication, the responsibility of establishing the guilt of the accused would be of the prosecutor. The test of choosing principles of evidence to be borrowed from another field is whether that principle is neutral or insulated from the peculiarities of the regime in which it has originated or it was applied. Also, principles of evidence would be in the nature of a secondary norm. Primary norms relate to rights and obligations, whereas procedural norms relate to procedures for enforcement of those primary obligations. To that extent, as a secondary norm, principles of evidence would detach themselves from the primary norm, which influences the subject matter. The next argument supporting similarities of approaches is the benefit of cross-fertilization. The International Court of Justice has a unique position in the contemporary architecture of adjudication. It is not only a de jure principal judicial organ of the United Nations, but it has become so de facto, by which I mean there is greater willingness of states to take diverse disputes to the court. This unique position and its reception among states gives a special relevance to its determinations on all aspects of evidence, which itself can be a good starting point for similar approaches. Other courts and tribunals often rely on decisions of the ICJ. As a generalist court, ICJ has to face cases involving different degrees of evidential issues. A survey of specialized regimes shows that they have developed expertise in handling different areas of evidence depending on the nature of cases that they have to handle. The WTO, for example, has had to deal with several cases involving expert evidence and have a fairly developed jurisprudence on those principles. Some Annex 7 tribunals or some ad hoc tribunals constituted under the UNCLOS have had experience of conducting site visits. Recently, the ICJ appointed a committee of experts to conduct the site visit. So there are certain branches, certain regimes which have a developed or an advanced way of addressing site visits, which could very well be harped upon to develop certain common approaches. In any adjudicative process, there is a challenge of drawing a balance between flexibility and certainty. Flexibility demands the need of adequate discretion for an adjudicator to analyze the facts on a case-by-case basis, while the parties to a dispute desire certainty in procedure and the process of adjudication. The process of drawing upon similarity in approaches across regime assists in developing a body of principles on evidence that can contribute towards certainty of the process of adjudication. We already have procedures in place, if not fairly advanced on evidence, but we have procedures of different courts and tribunals. In the absence of set identified principles, it is not clear to the participants of the process as to what is going to be the outcome. It is not clear how would a piece of evidence would be received, how it would be analyzed, and which exposes the possibility of parties trying to put a lot more evidence than necessary before a court or tribunal, which adds up to the time taken up in the adjudicative process. Looking at the current burden of the courts and tribunals, it is, in a sense, necessary from the perspective of judicial economy to have some clarity about how principles of evidence would be dealt with. One cannot insist on rigid rules of evidence in an absolutely definitive manner. But at the same time, they cannot be left unidentified. An analogy can be drawn with the drafting process of the rules of interpretation on the law of treaties, which eventually became Article 31 and 32 of the Vienna Convention. If that was a signal for me to stop, I'll be stopping very soon. When Articles 31 and 32 were being discussed at the International Law Commission, one question was whether identification of rules of evidence is going to destroy the discretion of the adjudicator. Instead of leaving the entire discretion to the adjudicator, the Commission and the states, through the Vienna Convention, concluded that they need a certain set of basic rules that regulate the process of interpretation. Otherwise, discretion without guidance will result in inconsistent decisions. The choice of rules and their arrangement was not easy. But if they were not identified, we would have had been in the uncertain phase where it would be difficult to distinguish the outcome of interpretation in one case from another. The process of identification of similar evidentiary practices across different fields of international law can form the basis for identification of that common denominator on evidence. The common denominator remains similar across fields. These common denominators need not be exhaustive. It would be a limited set of principles. and some of them can simply not be common. One example was burden of proof, which I gave some time back. A relatively controversial issue is the role and relationship between the civil and common law. As we know, there is a wide amount of discretion exercised by judges in common law. In civil law, unlike common law, where there are certain set of principles which an adjudicator is expected to follow. The distinction can work very well in domestic systems, especially the civil law systems where a judge has far more discretion. Because the judges in a domestic setup are aware of the political context, the cultural sensitivities, and the social realities of the adjudicative process. An international court or tribunal is in a sense insulated from the overall seriousness of the political context. That's precisely the idea. An international court or tribunal, at least an institution, the permanent institutions like the ICJ or writ laws, draw upon experts from different fields, from different jurisdictions, who neutralize the effect of their geographic priorities. That is an important aspect to keep in mind in order to balance out how principles of evidence would play out. I would not venture further into civil and common law similarities and divergences, but I'm very sure that as we go along, we would have a lot more things coming out as the day progresses. There's one important point that relates to this is how much to draw upon from domestic law. There is always a temptation to bring that experience. That's also one of the sources of general principles of international law as recognized under the sources of the law. But I prefer the cautious approach which was appended by Judge McNair in the Southwest African cases about how to deal with issues coming from domestic law. He says, and I quote, "The way in which international law borrows from this source is not by means of importing private law institutions lock, stock, and barrel, ready-made and fully equipped with a set of rules," end of quotes. While dealing with issues of evidence, it would be advisable not simply to borrow lock, stock, barrel from domestic legal systems. But the broader structural point, to an extent a philosophical point, is about fragmentation on the procedural law side. The focus on the debate of fragmentation until now has been on the substantive law. Avoidance of fragmentation on procedural side is equally important. This does not mean absolute uniformity. It rather contemplates similarity of approaches across different fields. It is also necessary because it feeds into the overall system of the international rule of law. International rule of law, of course, would expect certainty of rules and principles which are applied by different courts and tribunals. If there is such certainty to the users, private individuals and states, it enhances the credibility of the adjudicative process, the way in which the adjudicative process is perceived by the users. We have seen unprecedented increase in the number of states that are approaching and using these international courts and tribunals. We have seen an increase in the number of states from different regions who are using these international courts and tribunals. We are, in a sense, at a very important stage of international law, where we have sufficiently advanced substantive law. It's time for the procedural law. And I think our exercise of today's collective thinking focused on evidence would be an important step in this direction. Before I conclude, I wish to recall an anecdote or an experience I just had a couple of weeks back in the United Nations during the 6th Committee meetings. I was introduced to one of the judges of the International Court of Justice, and when my name was said, his eyes sparkled, and he said, "Oh, you are Rajput, the one who wants to tie our hands." I said, "Far from it. I want to strengthen your hands." And I'm very sure that our today's exercise is not in any manner to tie the hands of the adjudicators, but it's certainly aimed at strengthening the hands of the adjudicators and the process of international adjudication. Thank you very much.